like to welcome everyone to today's webinar, Riders and Notices Required for Rent Stabilized Leases and Renewals. I'm Heather Stone, Executive Editor of the Habitat Group. We publish the New York Rent Regulation Checklist, which is now in its 4th edition, the annual New York City Apartment Management Checklist, and the monthly newsletter, New York Apartment Law Insider. I'd like to thank Ann Korchak and Aaron Weber of the Small Property Owners of New York for inviting us to present today's webinar. After our presentation, we'll have approximately 15 minutes for Q&A. There should be a little Q&A section on your screen where you can type in questions. Maybe hold off till later in the presentation in case we answer some of those questions before we get to the Q&A section. Also, don't feel like you have to take furious notes because you will be getting a copy of the slides as well as a copy of the forms that we refer to and a link to the recording of the webinar. Within a couple days. It might take a couple days for the webinar recording to come through, but we'll try to send you the other materials sooner. Okay, and now I would like to introduce our speaker, Eileen O'Toole. She's the principal of the law office of Eileen O'Toole. She counsels owners and prospective purchasers of residential properties on rent regulatory issues, and she appears in court actions and administrative proceedings to litigate disputes over leasing, rent overcharge, vacancy deregulation, exemptions from rent stabilization, and other housing issues. She's a frequent lecturer on rent stabilization requirements and is the author of the New York Rent Regulation Checklist, published by the Habitat Group. She also writes Habitat's monthly case digest, Landlord v. Tenant, and edits the annual New York City Apartment Management Checklist. Thank you, Eileen, for giving us this presentation, and take it away.
Okay, hi, thank you, Heather. Hello, everybody. Heather, you can go to the next slide. The beginning slide here is just a summary of what I will try to cover quickly in about 40 minutes to leave some time for questions and answers. What I will say, this presentation is primarily about riders and notices required with rent stabilized leases and renewal leases. I understand a lot of SPONY members have questions about the riders required for stabilized and even non-regulated residential leases, because it seems like every time you turn around, there are more and more riders added, and some of them are required under the rent stabilization law. And then there are other riders required under various provisions of city, state, and even sometimes federal law that need to be added to leases. So what this is laid out here for you on this page and the next page. Just what I will do first is just remind people of the distinctions between rent stabilized and rent controlled tenancies that affect leasing requirements, the distinctions between rent stabilized and unregulated tenancies. And then I have a list here of the lease riders that I'll talk about and that you'll have copies of in the materials. In addition to the slides here, there's a PDF you'll receive with copies of all the lease riders that we talk about. So the first thing, next page, Heather, next slide. The first thing I just want to remind all of you about, many of you probably realize this, the two primary rent regulation methods we have in New York City are the old rent control system and the newer, such as it's not that new anymore, rent stabilization system. And rent control tenants are called statutory tenants. And what that means is when rent control tenants moved in, which generally was before 1971 or the middle of 1971, they often received an initial lease that you still may find in a lease file, but there's no leases after that. And that is because rent increases under rent control have long been governed by statute and require an application filed to DHCR under the MBR program for rent increases. That doesn't mean you don't have to give rent control tenants some of the notices that are required by law, and I'll try to mention that as we go through the different riders. So that's the basic thing about rent control. Then we have, I know there were some questions. We're going to really primarily focus on rent stabilized tenancies, but in rent stabilized buildings, a lot of apartments over the years eventually became vacancy deregulated. There's no more vacancy deregulation since 2019, but you have many apartments in rent stabilized buildings that are permanently exempt apartments. And for those apartments, a lot of the riders that are required by city and state law are also required for non-stabilized rent stabilized tenants. There are some, we're not really going to be talking about lease terminations and reasons for not renewing leases in this program, but there are some differences in how that works for unregulated tenants. And there are some differences in what you have to do by law when it comes to returning security deposits. So we're not really focusing on that, but there are some distinctions between stabilized and regulated and unregulated tenants. Okay, the next slide. What I wanted to mention first, because it would affect the beginning of a landlord-tenant relationship before you start signing leases, and you could give it to the tenants with the leases. New York, like a lot of other places now, permits electronic signing of agreements that can then be made binding. For lease agreements under rent stabilization, there are laws and regulations that require you to have forms that are filled out and signed by tenants, such as the renewal lease forms. But now, by law, leases can be signed electronically, but what you need to do for rent stabilized tenancies is first have the landlord and tenant sign a form that DHCR has issued that acknowledges that everybody is signing the lease electronically. One of the forms that's in the package of forms you're getting is the DHCR form for this purpose, and it has pretty clear instructions on what to do. So that form I would fill out when you're starting a tenancy, or upon renewal, if you want to ask the tenant if they'd like to do that, you can do so. Generally you can't change the terms of a rent stabilized tenancy when you renew the lease, and you cannot force a tenant to sign leases electronically. It's voluntary, and if they don't want to do it, they don't have to do it. In a lot of instances, it may be the other way around. You may have tenants who actually want to be doing electronic filing, and certain property management offices may not have those procedures in place for doing that. So okay, so that's the first thing I would have ready if you want to have electronic signing when you're ready to enter into a lease agreement. Okay, what I wanted to do was just talk a little about what are the basic requirements for rent stabilized leases. Again, the electronic lease provisions are now permitted. Generally, the rent stabilization law says that owners must offer new rent stabilized tenants the choice of a 1 or 2 year vacancy lease. As a practical matter, I will say that I have rarely seen, in reviewing various documents and lease files over the years, I have rarely seen a 2 year vacancy lease. I believe that many owners just don't offer 2 year renewal, 2 year vacancy leases. And I have rarely seen complaints about that. Sometimes that does come up in an overcharge complaint. The tenant will say, I was not offered a 2 year vacancy lease. I was only offered a 1 year vacancy lease. I haven't seen enough cases on that to even recall what the decisions were on it, but as a practical matter, it doesn't tend to come up, although you are supposed to give the tenants a choice. There were various ways that rent increases for vacancy leases have changed since HSTPA, that was June 14th, 2019. And for many years, you had a 20% rent increase for a 2-year vacancy lease, and it was a little less than that. It would be like 16 or 17 or 18%, depending on the calculation, for a 1-year vacancy lease over the prior rent. There are no such increases available anymore. Owners can only collect whatever the renewal guidelines are under the Rent Guideline Board orders for a vacancy lease, plus adding in any IAI or MCI or other increases that may apply. The next slide, please. Okay, longevity increases also don't exist any longer since 2019, since HSTPA. And one thing that's been around for a while, and this goes back to 2011 at least, if you have more than one turnover in a year, you have a tenant moves in, say in March, and you take a vacancy increase, and then that tenant moves out, a new tenant comes in September, October, you cannot collect a second vacancy increase during the same calendar year. You have to charge the same vacancy increase that you charged the prior tenant. Another thing to keep in mind is that if you have a vacancy lease for a new rent stabilized tenant, but there's a DHCR rent reduction order in effect, based on decreased services, and the rent hasn't been restored yet, you are not supposed to collect a rent increase while that order is in effect. It doesn't mean that you can't calculate the increase for purposes of having it in the lease and for purposes of preserving what the legal rent is supposed to be, but you're not supposed to collect it. One thing that I don't have the answer to at the moment, but has been a frequent question in the last few years and is probably going to be more of a question now, is what happens if an owner creates a new apartment, either takes 2 adjoining apartments and combines them into one new larger apartment, or takes a larger rent stabilized apartment and splits it in 2, or splits it 40% here and 60% there and creates 2 new apartments. Previously, a new rent could be set, and that was the starting point going forward for a new rent stabilized rents that could be significantly higher than the prior rents. There are pending amendments to both the Rent Stabilization Code and the Rent Stabilization Law, which we're waiting to see if Governor Hochul signs off on them, that is now restricting what you can do when you combine apartments. And, to put it in the simplest terms, if you have 2 apartments and each rent was $1,000, you combine them, your base rent now is supposed to be $2,000 for the new apartment, plus any IAI or MCI or other increases you can add on. If you have 2 apartments, if you have an apartment that was $2,000 a month and you split it into 2, each rent is base rent is supposed to be $1,000. So there's likely to be confusion and fights and proceedings about how that's going to be applied, whether it can be made retroactive, whether it will just apply going forward. And there's probably going to be something more happening with that within the next couple of months. So you just have to kind of keep a lookout for what happens with that. Okay, the next slide. Starting off, getting back to forms, I have not included them for this presentation, but there is no specific form that an owner has to use for a rent stabilized vacancy lease. There are a number of companies, REBNY, the Real Estate Board of New York, Bloomberg, RSA, all have designed and issued and sell their own form vacancy lease for rent stabilized tenants. They also do them for unregulated tenants, but you have it for rent stabilized tenants. And there are a lot of provisions in these leases that are pretty standard. And I'll just point out a few of them that you can pay attention to, or sometimes people decide to take things out or change them a little. Standard vacancy lease forms include a due date. It doesn't always say rent is due by the 1st of the month. It may say the rent is due by the 5th of the month, which matters only if you're at the point where you want to be sending a tenant notice that their rent's overdue. You're supposed to wait till the, to the due date for that. Standard vacancy leases usually include a jury waiver clause. If an owner has to take a tenant through landlord-tenant court for non-payment of rent or because they want to evict them for some other reason, generally you can't ask for a jury trial. Since in New York City we have a housing court and the judges are pretty experienced and know what the law is, it generally does not hurt either side, probably, that there is no jury provided in New York courts. But if you are giving a tenant a lease and decide you want to get rid of the jury waiver clause, you can just scratch that out of the lease. Next slide, please. Standard vacancy leases also include an attorney's fees clause. That means that if the owner has to take the tenant to court for violating the lease and the owner wins the case, the owner can ask the court to award them attorney's fees. So by law, even though the lease may not say that, if the tenant wins the case, the tenant can ask for attorney's fees. I have occasionally seen clients, owners of buildings who take this clause out of the lease altogether because they just don't want to have to deal with it if they are in court with a tenant. Everybody may have different ideas about that and whether they want to do that. If you have questions about things like that, you may want to talk to a landlord-tenant attorney who does a lot of this kind of law. Another thing that is a standard vacancy lease provision is a security deposit provision. You have to say what bank you are holding the tenant's security deposit in. And under rent stabilization, 1 month security deposit is the maximum collectible. I believe that is also now the maximum collectible for unregulated tenancies. And one of the things I've noticed more with unregulated leases than with rent stabilized leases is in recent years, some owners don't even collect a security deposit. They may ask the tenants to use some other kind of program for ensuring that there's coverage for apartment damage. But since there are provisions in the law for unregulated tenants requiring you to return the security deposit within 2 weeks, or you're going to lose your right to withhold it, I have seen some owners opt not to collect a security deposit anymore. Another thing that most vacancy leases have is some kind of boilerplate guarantee provision. And I have seen that a lot of owners do ask new tenants, particularly if they're younger people, to have someone guarantee that the rent is paid. And generally, you cannot go after a guarantor for non-payment of rent if you're suing a tenant for non-payment of rent. But if you win and get a judgment against the tenant for non-payment of rent, you can then go after the guarantor to get the payment. There's been a lot of litigation over guarantor provisions, particularly during the COVID period, and maybe more so in commercial cases because there was just a lot of default going on. And there are some things to pay attention to about guarantees, whether they need to be in the renewal leases to continue to be enforceable, and some other questions. And again, if you want to include a guarantee provision and want to make sure that the boilerplate one in your lease works, or that maybe you should be doing something else, I would speak to an attorney before you sign off on one, or before you start seeking to enforce it. You can't be calling up the guarantor when rent is due and threatening to sue them when you don't have a judgment for the unpaid rent. Okay, one thing I'll point out here, it's okay to switch the slide, but I gave you a form. One thing to keep in mind, if you are giving a vacancy lease, a new lease, to a rent stabilized tenant for the first time because the apartment was previously rent controlled, the rent you may agree to is the fair market rent, but there is fair market rent appeal provisions in the rent stabilization law, and the first rent is subject to challenge. And the first rent stabilized tenant should be given an initial registration form, the RR1 form, when you sign the lease. I've given you a copy of the RR1 form with the lease rider forms. And if you give the new tenant, the first rent stabilized tenant, the RR1 form, and you have proof that you gave it to them at the time you entered into the lease, the tenant has 90 days to challenge what's the fair market rent, or else they can't challenge it after that. If you don't give them that form, it becomes like a rent overcharge case that, 6 years later, or for a 6-year period, the tenant can still challenge the first rent. So giving the first stabilized tenant a RR1 registration form to show that the apartment used to be rent controlled and now it's rent stabilized is important to do, just to prevent the liability period from running for a number of years instead of for 3 months. Okay, that's all I'll say about vacancy leases right now, but we're on the right slide. I'm just not up there. Renewal leases. DHCR issues a form for rent stabilized renewal lease. It's on their website every year. And when the new guidelines come out, like they just did in June, DHCR issues a new renewal lease form. The latest renewal lease form that goes into effect October 1st is included with your package of materials. By law, the renewal lease form is supposed to be sent to the rent stabilized tenant between 90 and 150 days in New York City before the lease expires. I'm also focusing here on New York City rentals. We do have rent stabilization in other counties and some other cities in New York state now, and the timing, the deadlines may be a little different outside of New York City. But we're focusing on New York City here. So you send the tenant a timely renewal lease offer. The tenant has 60 days to sign off, choosing a 1 or 2 year renewal lease, or letting you know on the bottom that they're not going to renew the lease. And then once you get the fully executed, the signed renewal lease back from the tenant, the owner has 30 days to send back the fully executed lease. And maybe when we get to the Q&A, just so I make sure I cover everything, if people have questions on what happens if you are late sending the renewal lease offer, we can talk about that. Okay, so I have the new RGB. I think it's number 55. RGB order number 55 starts October 1, 2023, and we have the renewal lease form for that. One of the things that DHCR has nicely provided this year, I include that also. There's the renewal lease form that's going to go into effect for the next renewal period. And they have one that they filled in to show you how to do it. And you wonder, well, why do they need to show me how to fill in the renewal lease form? That's because, once again, the Rent Guidelines Board has split the guideline increase. This is something, they didn't do it last year. Under the current guideline, it's 3% for a 1 year increase. No, it's 3.25%, and then it's 5% for a 2 year increase. There have been a few years before that, and now they did it again, where they split the guidelines during a guideline year. Whatever anyone thinks about how this makes the rent increases fair or unfair, or more fair or less fair to one side or the other, it seems to me that it could be an administrative nightmare. Right now, under the new guideline that starts in October, the 1 year increase is 3%, and the 2 year increase is you can collect a 2.75% increase the first year, and then you can add another 3.2% increase the second year, but you can't collect the full security deposit until the second year. You can, you collect that in pieces too. And how you do the rent billing and how anybody understands what they're supposed to be paying, I just think can probably be the source of a lot of headaches for people. So I was a little surprised that they went there yet again this year. One of the things I'll mention is some of you who've been managing rent regulated properties for a long time probably remember deemed renewal leases. If you had a tenant who would not sign the renewal lease, even though you sent them reminders and sent them and had proof that you sent the renewal lease offer, you could still charge the renewal increase that was effective if you had proof that you'd sent the renewal lease. You can't generally do that anymore. And if you do collect deemed renewal leases, you can have a problem later on if somebody complains about it. Okay, next slide. Tenant, as you may recall, if you have a rent stabilized tenant, they can ask that their spouse's name be added to a renewal lease. And as long as the spouse resides in the apartment as his or her primary residence, the tenant is entitled to that. You can't really not agree to that. And if the tenant files a complaint that you didn't add the spouse's name to the renewal lease, they will probably win in DHCR. Okay, so I think we've covered what we need to cover there. The next slide. Oh, and similar to the, no 2 vacancy increases, you can only collect the renewal increases once during a guideline period, even if for some reason you have a change in tenancies. I mentioned what I thought about split guideline increases. And another thing that I don't have a form for here, but I have seen owners use some kind of rider to leases. There are probably some of you who have tenants who received ERAP funds to pay rent, during the pandemic period. And one of the restrictions on accepting ERAP funds to pay for rent is that you cannot increase a tenant's rent for a year. Now, you may have a renewal increase that comes up during that time, and that doesn't mean you can't document what the rent increases are in a renewal lease, and you should. And sometimes you have both the legal increase and the preferential rent increase. But what you can collect because of ERAP is a lower amount, at least for part of the renewal period that you enter. So some owners do prepare a rider that they will add to the leases in that instance. Okay. Oh, okay. So here again, I'm just mentioning here the first rider, I'll call it a rider, that you'll see in the package, or one of the first that you'll see in the package, is the DHCR electronic lease offer form. It's pretty straightforward. It's a 1-page form that both sides have to sign. And anything like this that you have, a 1-page form for both to sign, you should have 2 copies, one to go with each side's copy of the lease. Okay, next slide. Okay, an important rider for any rent stabilized lease, and it's a long one because it's at least 11 pages. It might be longer than that at this point. You have the DHCR lease rider. If you have a new tenant with a vacancy lease who is rent stabilized, you have to provide this form. You have to attach it to the lease. And one of the things you have to do when it's a vacancy lease, a new lease, is you have to use the first couple of pages of the form to calculate how you got the rent increase in the vacancy lease. And while it may be a low increase just by the guideline increases now, you also have to identify how you calculated any increase you get for individual apartment improvements. And those, as many of you probably know, those increases are much lower than they used to be because how much you can collect is much lower than it used to be, but you have to set it forth in the lease. The rider also tells tenants that they can ask the owner for documentation of how these rent increases were done. And if it's requested, you're supposed to provide that information. The next slide. Okay, the law says that you can give the DHCR lease rider within 60 days of signing a vacancy lease. I think we should just include it with the lease and get it over with. It has a signature line for both sides to sign. And, I looked up this morning, what is the penalty if you don't actually provide the rent stabilization rider? And what the law says is that if you haven't given a tenant a DHCR lease rider, you can't collect the rent increase you could otherwise collect unless you can show that it was a lawful increase. Now, whether you've given somebody a DHCR lease rider or not, if someone's claiming that the rent you're charging isn't legal, you have to prove it anyway. So I'm not sure what that penalty actually does. But again, I have seen generally what I see in doing lease file review in a lot of instances, I will see DHCR lease riders attached to vacancy leases for new tenants. I don't always see it with renewal leases, but you are supposed to provide the lease rider to the tenants with both vacancy and renewal leases. If you use these forms regularly, check DHCR's website because periodically they revise or amend the rider. The last time they amended the lease rider, to my knowledge, was in March of this year. Okay, next thing, preferential rent riders. A lot of rent stabilized leases have had for a long time or still have the preferential rent riders. And as many of you may know, you have the legal regulated rent that you're allowed to charge under rent stabilization. But if you decide to charge a tenant less, you can do that. But you should document it in your lease and you document it in your rent registrations. And even in your renewal leases, the renewal lease forms will have a box that says, are you charging the tenant less than or a different amount than what the legal rent is? And you check yes or no. And then it'll ask you, have you attached a form for that? And not everybody does all the time, but it's a good idea if you're giving a rent stabilized tenant a preferential rent, that every time you renew the lease, add a preferential rent rider. I've given you samples of those using for a vacancy lease and for a renewal lease in the package. And this way you have preserved your documentation of having a preferential rent, because I have seen various rent overcharge complaints where the DHCR will go back more than 4 years or now more than 6 years and ask you for leases from before then if they're trying to confirm whether there was actually a preferential rent. Sometimes there are cases where the owner will say the rent that was charged was a preferential rent, but there's only one rent on the lease. And the DHCR will say, you can't claim this is a preferential rent because there's no proof that there was a higher legal regulated rent. So, this is the rent. One thing since HESTPA went into effect in 2019, say you had a new rent stabilized tenant, you give them a preferential rent with the vacancy lease. You used to be able to discontinue the preferential rent when you renewed the lease. You can no longer do that. If you give a tenant a preferential rent when they move in or later, upon renewal, that tenant has to continue to get a preferential rent, and it is subject to the rent guideline increases every time you renew the lease. The other thing, maybe I'll get back to a little later if we have time in the questions, there is a difference between a preferential rent, which is something that, the legal rent's $1,500 a month, and every month you collect $1,200 as a preferential rent. That's a preferential rent. There's also something called a rent concession, where an owner will give a tenant, say, a 1-month rent concession or a 2-month rent concession. Sometimes this happens with new buildings under the 421A program, or if there's construction or something going on that creates some inconvenience, so the owner wants to give the tenant a break to help get the building rented. So the lease will say your legal rent's $1,500 and you don't have to pay the first month's rent, or you don't have to pay the last month's rent, or you have 3 times you won't have to pay the rent. That's okay up until about 3 months. DHCR hasn't questioned a rent concession and it's legal, but there has been litigation and court cases I don't think there's really final decisions on some of these cases. And I've noticed, I think in some proposed changes to the law. There was something about rent concessions, but I don't think that that's gone through at this point, where what the tenants have argued is that these rent concessions are just a backhanded way of charging a preferential rent, that it's not a separate and a distinct thing. So it should be treated as a preferential rent. So that's a potential issue. If you have questions about what you're doing with rent concessions, that's something, if you have a landlord tenant attorney you work with, I would ask them about that and what the current law is on that one. Okay, preferential, that's enough about preferential rents at the moment. The tax benefit riders, and I will say that the rent concession issue I was just talking about has come up primarily where I've seen it in cases about 421A tenants, because when you have a building that became rent stabilized, because it's a new construction, so it wouldn't be rent stabilized, but you took the 421A tax benefit for a period of time, the building becomes subject to rent stabilization for at least as long as you're collecting the benefit. And you're not supposed to charge a preferential rent for the first rent. You can do it afterwards. But say you had new tenants come in, the first tenants in the building, and you know, you could have charged $1,500 a month rent. You gave the tenants a rent concession so that they were actually paying a lower rent than the $1,500 you were entitled to collect under 421A. There are a number of cases now where the tenants are saying, wait, that was a backhanded way of charging a preferential rent, which you're not allowed to do with the first rent, and therefore there's a rent overcharge. So you have to be careful about that. But otherwise, the tax benefit riders, what those are about is making sure if you're under 421A or if you're under J51, that every time you give a tenant a vacancy lease or a renewal lease, you give them a rider saying, you know, hello, you're subject to rent stabilization because you're under this tax benefit program. We believe it's going to expire, you know, 15 years from now. And at that point, the apartment won't be stabilized anymore. So if you have an apartment that could become exempt after the tax benefits are over, but you didn't give the tenant the lease rider in every lease, that tenant can remain rent stabilized. And another thing to keep in mind is that there are some buildings that are subject to rent stabilization, even if they didn't have the J51 program and the J51 rider. So it's not even going to matter. They may still be rent stabilized. But again, that's something you can check on if you have a building that is under that category. Okay, here's a simple one. You may not even have to worry about adding this type of rider most of the time. If you have a rent stabilized tenant come in, they're under a vacancy lease, and you have a pending application for an MCI rent increase with DHCR. If the vacancy lease doesn't have a clause in it saying that the rent is subject to increase during the vacancy lease term, if your MCI increase is granted, you won't be able to collect the increase during the vacancy lease term. Most of the boilerplate leases I mentioned to you, under the, you know, the standard vacancy lease forms have language like this included in them. Sometimes if you're using a lease form that may not be one of the standard ones, or it's older, you check if you have this language in it, if you have an MCI application pending, because otherwise you'll get a delay in collecting the increase. Renewal, if you look at the DHCR renewal lease form, it always has a line in it saying that, you know, the renewal rents are subject to increase if you have a DHCR order that gives you a rent increase. So that's something that's pretty much covered in the language of leases, but it's just something you should, if you have a checklist of things you're looking for or thinking about in your leasing procedures, that's one of them. Okay, next. Another kind of simple one is, and this went into effect, I keep thinking it's brand new, but it's almost 10 years ago, that now leases are supposed to have, and again, if you use older standardized leases, you may not have this language in it, and then you could just add this language. And this language is in all the DHCR renewal forms. If you have to say whether the building has an operative sprinkler system, and if it does, you have to give the date that it was last inspected. So that's just some, further information that you have to provide. All right, the lead-based paint notifications. One of the things I do for Habitat is edit annually the apartment management checklist, which a lot of, I think a lot of Habitat subscribers like that book. But there are 5 chapters in that book about lead, because there are so many aspects to notifications and curing lead violations, and there's more than one lease notice that has to do with lead paint, which supposedly hasn't been used in buildings, in over 50 years. So, why we still have lead, I'm not saying there aren't lead paint issues, but why there are still lead paint issues for something that's not really even supposed to be used anymore is kind of an interesting question. But anyway, and I have found it confusing, but lead paint in apartment buildings, it's the subject of federal law, it's the subject of state law, it's the subject of city law. And what you're supposed to do, there's several things you're supposed to give tenants, and it can be confusing about whether they should get these things with the renewal leases, but certainly starting out with the vacant leases. There's a pamphlet, many of you have probably seen it. It's called Protect Your Family from Lead in Your Home. It's EPA or HUD that puts out this pamphlet. You can find it online. There's a copy in your package here that you got with our materials, and tenants have to get a copy of that. There's also a form that this one comes from HUD or EPA. It's a disclosure of information on whether there's lead-based paint in the apartment that you're moving into. Okay, next, because we're still on lead paint here. There's an HBD form where you're inquiring from the tenant as to whether they have children in the apartment who are under 6 years of age. That's important because that's where the law has penalties for not clearing up lead paint, and then you have children who become sick or develop disabilities because of exposure to lead paint or lead paint chips or lead paint dust. And so this form, which you are supposed to provide with both vacancy and renewal leases, requires the tenants, it puts the onus on the tenants to notify the owner if there's a child under 6 who lives in the apartment, and also if it's a child who frequently visits the apartment for at least 10 hours a week. And that can come up if you have, say, someone who stays with a grandmother or stays with a caregiver. You may be someone who doesn't have children, but you've got a child in the apartment for enough time every week that this provision is going to, hit you as well. The next thing here is the window guard rider. Similarly, this is something that owners should give the tenants in vacancy leases and renewal leases. And actually, this is an annual requirement to give these notices. So I've seen people, give it with the vacancy lease, but you're supposed to send it annually to tenants at the beginning of the year anyway, so that may cover it. There's this combined notice. I give you a sample in the package of forms where not only are you saying whether you've got a child under 6, but you're saying if you've got a child and whether you want window guards. Some people want them, some people don't. So that's something you're required to give tenants also. Okay, bed bugs. This has been around for, it's a while now, over 10 years. There's a notice to tenants disclosure of bed bug infestations history. DHCR provides this form. It's on their website. I give you a copy of it here. That was in 2010, that started. And then since 2018, under local law, you now have to do electronic filing annually with HPD advising about bed bug history. So that's something whether you're rent stabilized or not, you're supposed to get these bed bug notifications. Next, the smoking policy. I think that's next. Yes, okay. This has been around since 2018. There are various samples of it floating around. We have one attached here. Residential buildings are supposed to have smoking policies. Doesn't mean you can't permit smoking in apartments. You can if you want to. Some owners have opted at this point to prohibit smoking in residential apartments because there are enough cases where you start having disputes between tenants. There was a lot of that going on during COVID where you had people home more of the time. And smoke from somebody's apartment can filter in to other people's apartments, especially if the smoking is heavy. So you are supposed to notify tenants of your smoking policy and put it in their lease. But the catch is that if you have a rent stabilized or a rent controlled tenant who've been in there for a long time, and it was never part of their first lease that you can't smoke in your apartment, you can't make the tenants comply with such a policy at this point because it was never part of their lease. So that's the catch here. I was looking to see what the penalty was for not providing the smoking policy notification, and the only thing I saw was that you can get $100 fine from HPD, I think, if you don't give tenants a copy of this policy. Okay, that's enough about the smoking policy. All right, the next thing, these are separate things, but they can be combined into a notice. There's a lot of concern about gas leaks anymore. We've had a few tragic cases in the city with explosions where there are gas leaks or people trying to siphon off gas. So there's a notice. This is a notice that's supposed to go up in the building, but you can actually then give it as a rider that you tell people who they call, and in Manhattan it could be Con Ed, or it's a different utility company outside, and you give them the phone number, who to call if there's a gas leak. And the combined notice that we include here also tells owners and tenants what owners are supposed to do when installing smoke detectors and carbon monoxide detectors in apartments. So that can be in a combined notice. The next thing here, the recycling rider. There's a standard New York City recycling notice that's supposed to be posted in buildings, but a lot of times owners just, opt to provide it as a lease rider with vacancy and renewal leases. That's something that applies whether you're rent stabilized or not. Next thing is just kind of going to rush through the last few here because I want to leave some time for questions. There's an indoor allergen rider and pamphlet that the city law requires you to give tenants. And two new things that have come up last year. We had the reasonable accommodations notice that the New York State Division of Human Rights has set up, and it's a little different in New York City because you can't make tenants pay for the accommodations in New York City. But this is the notice where you are telling tenants, look, if you have a disability, you're entitled to request a reasonable accommodation. For example, if you have people who are mobility impaired and they want some kind of shower bars put in, that's relatively easy. It can be more problematic if people need a ramp to get into the front of a building, and some buildings just aren't constructed in a way that makes that easily accessible. So then you have to figure that out. All right, and then the newest notice is the flood. I'm calling it the flood zone notice. This just went into effect last month, and you now have to give all tenants notice of previous flood history and current flood risk of the premises. There are city websites that probably let you know whether your building's in a flood hazard zone. And DHCR has issued a sample of this notice, which we provide and is on their website. And the final notice, I'll just mention that I forgot to put it in the PowerPoint, is that there's a DHCR notice, and this one's optional. You have to decide whether you have reasons to send this or not send it. There's a notice that you can ask tenants to give you a list of any occupants in the apartment that may have a right to claim succession rights. And you can't send this notice more than once a year. And the tenant doesn't have to answer this notice. So it may be a strategic decision in different cases about whether to request this information. If you request it and no information is given to you, and then the tenant's family member is later claiming succession rights, you can try to use the fact that nobody told you anything, even though you asked them, but it can work the other way too. So you have to make a decision about that. And that's all I have to say at the moment. And I'm sorry, I went a little over what I intended to do, but we'll see now what we have question-wise.
Okay, thank you very much, Eileen. Okay, let's see. In a standard amendment form to rent stabilized renewal lease, can the landlord charge rent stabilized tenant for repairs such as replacement of windows, repair of bathroom fixtures, upgrade of electricity, and include the cost in rent?
I'm not exactly sure what you're asking about, but the short answer, if I understand the question, is if these things are not MCIs, if you're not doing it on a building-wide basis, you have a rent stabilized tenant in occupancy, and you want to charge them for doing what would be individual apartment improvements. If the tenant is in occupancy, you can't collect that from them unless they have consented to it. And you still have much stricter limits on how much you can actually collect, because it would be considered an individual apartment improvement. Okay. But in theory, it could be done, but it would be something, sometimes that comes up, you may have long-term stabilized tenants who want certain things done. If it's something that has to be done because it's a repair, it's not an improvement, it's the owner's obligation to make a repair. But if the tenant wants certain improvements, even if you have a tenant who wants a new refrigerator and is willing to pay for it, you can negotiate that with the tenant, subject to whatever the law is.
Okay. Can the new renewal lease be printed on a standard letter paper as opposed to the legal paper that it is set at?
I think it is in the law regulations that it's supposed to be the size that it is, because if you print it out on letter size paper, it reduces the size of the print. And the issue is not really how big is the paper, it's how big is the print. So that could be an issue if it's not legal sized.
Okay, somebody asks if the PDF of the forms will be emailed, and yes, they will be emailed with the copy of the slides after the presentation. Give us a day or two, because we'll also send you a link to the recording. If the tenant doesn't sign the renewal lease with the increase and keeps paying the old rent, what can you do?
Aha, I was hoping so. Okay, the tenant doesn't sign the renewal lease, and let's assume for purposes of the question that they're wrong, that they don't have a good reason or valid reason for not signing it. Like, you added 14 riders that never existed, and they're saying it's an improper renewal lease, or the numbers are wrong. If a tenant doesn't sign the renewal lease, and if you don't have a signed renewal lease, you can't increase the rent. The only thing you can do, which is a problem in and of itself because it's time consuming and can cost you money, is you have to bring an eviction holdover proceeding against the tenant for refusing to renew the rent stabilized lease. And you have to show that you sent them the rent stabilized lease. And then if you're going to court and they have no real reason, or they have an incorrect reason for not signing it, they lose. My experience with this for many years, before COVID, before HSTPA, before various changes to the law, is that the courts usually would give the tenant the chance to fix the issue, that they'd let them cure if they had no real valid reason not to sign the renewal lease, and the court says to them, you have to sign this or you're going to get evicted, and then they sign it. That'll be the end of it. But that may be all you can do. And it's a question, I have seen cases where people just don't do anything for a while because it's too much money and energy for them to deal with. But that's your remedy, is to sue to evict them for not renewing their lease.
Okay, with an ERAP payment, Since the tenant can't receive an increase for a year, are they to be noted as a preferential rent on the lease?
That the ERAP rent freeze is not a preferential rent. Sometimes you have cases, so what you have the lease, and sometimes you actually have a preferential rent, which is a whole, you can have a lease that has, you know, a legal rent only. That's and that gets increased under the renewal lease. But if the ERAP rent freeze ends 6 months into your 1-year renewal lease, then the legal rent resumes, you know, 6 months later, the collection of the legal rent. But no, the ERAP rent freeze is not a quote unquote preferential rent. It's
Okay.
just, it's an ERAP, you know.
Should we send RR1 via certified mail for an apartment going from rent control to rent stabilized, rather than give it to the tenant at lease signing to protect or prove that it was sent?
I have seen over the years, I have seen that done both ways. Some owners have been comfortable with and have been able to prove that it was part of the lease package and they've got a signature from the tenant at the bottom. I have seen other cases, and in some ways, it often seems to be better proof to have, you know, because you have to send the RR1 by certified mail return receipt requested. So you could do that and have your certified mail receipt. The problem sometimes with that is that if they never accept the certified mail, it comes back to you and then you have to maintain the envelope. I have seen it done both ways. I have seen it done both ways successfully. You know, that may be something, if you're trying to figure out what to do, you may want to check with, you know, either a professional management company or RSA or CHIP as to how they recommend people do this, or check with a landlord tenant attorney. And it may depend on the circumstances of your, you know, particular case also. But I understand the concern about that. I would wonder about that myself.
Okay. How can we enforce apartment insurance requirement? Is it a requirement? I guess you require someone to have renter's insurance.
Yeah, and that's a standard lease provision in a lot of the boilerplate vacancy leases. Again, and I don't know how far it would get if it is a lease provision that you get that, and maybe emphasize the requirement for that in your lease if it is particularly important. I don't know where exactly you get with a proceeding for, you know, send a notice to cure, and then if it's not cured and they don't get the insurance and the termination notice. I haven't seen any case decisions on this that I remember, so I'm not sure how far it would get in housing court, or if it's something that the tenant would be given an opportunity to cure again. Otherwise, and you wouldn't want to wait for this, you know, it could come up in litigation if the tenant didn't get the apartment insurance and there's damage because, you know, for something that they were supposed to cover and didn't have the insurance for. You may have a claim against the tenant, but you know, your remedy seems to be to go after them for not complying, for breaching their lease. And I'm not sure where it will get if there's been no actual harm.
Okay, if I already served the lease renewal without the riders and the tenant signed the lease renewal form, is it okay? Do I have to serve them again with riders?
As a practical matter, I wouldn't be so concerned. I wouldn't think that you have to do over the whole lease. You know, a lot of the lease riders don't require signatures. If you're concerned about getting certain riders to the tenants after the lease has been signed and fully executed, you could send them a package with a cover letter saying, here are some riders that were omitted from your lease, and you know, just send it in a way that you have some some proof of mailing and then keep it with your lease file. You know, keep in mind with some of these notices and things that have come up, like you know, the accommodation rider that came up last year. I think part of the law instructed owners to send copies of that notice to people with, you know, that were not new tenants, that were existing tenants who wouldn't have had these notices. You have to send it out to them in 30 days or something. But again, I have seen many, just in doing lease file review, you know, when I've represented people who are potentially buying buildings, you know, I've done a lot of reviewing lease files in sellers' offices, and there are a lot of instances where renewal leases don't have a lot of the required riders. And what happens individually in those cases, you know, a lot of times maybe nothing happens. There are different apartment management checklists, might be a good source to check this out for some of these things that, you know, are covered in that book, and they might give you some more information about penalties. I think sometimes, you know, what can happen too is if you haven't provided certain riders and then there's an issue that comes up that involves the topic of the rider, you know, there can be a question of who's responsible or who had noticed that you were supposed to do this if you never sent the, you know, sent the rider.
Okay, well, it's 12:01. I'm going to ask one more question, just so I think Anne from Spony might be on here, and I'll try to get her to pop on for a second. But in the meantime, if a single female tenant is the only person on the lease, but then a boyfriend or husband moves in and they have a baby, am I obligated to offer them to add the spouse and or child, one but not the other? Okay.
The only person you are required to add is a spouse. That's a heterosexual spouse, that's a gay spouse, but that is a spouse. Boyfriend or girlfriend is not a spouse. Child is not a spouse. So there is no requirement to add other family members as co-tenants to a rent stabilized lease.
Okay, I think I have Anne on here. I wanted to thank you, Anne, for giving us the opportunity to present today's webinar, and thank everyone for attending. Again, we will be sending out a copy of the slides and the forms and a link to the recording as soon as it's available. And thank you, Anne. Are you, there you are.
Yes, I am here. Yes. Yeah, I wanted to say thank you as well. You know, a lot of us small operators really kind of struggle a lot of times with the complexities of, you know, these obligations. So, you know, having a resource like this video and the, you know, materials that you'll provide will be a big help. So I'd like to say thank you, you know, on behalf of all the members that are here today. And
Okay.
we hope, you know, maybe in the future, if there's some other topics we should address, you know, this is a great format. I think typically people are able to, you know, carve out an hour of the day to jump on something like this or take advantage of the recording, you know, at a time that works better for them. So I thank you both.
Great. Well, thank you. And have a great day, everyone.
Okay,
Okay,
thank
thank
you.
you. Thank you, everybody.
Okay, bye-bye.
Bye.